Welcome everyone who's joining this conversation of Women's Declaration International USA. We're here tonight to talk about the very exciting decision that came down from the Eastern District of Tennessee Federal Court today. And we'll just wait a few minutes. We're getting more and more attendees. I will be turning my video on soon, as will Vice President of WDI USA, Lauren Levey. I see more attendees are joining, so I'm just going to leave another minute or two before we start the formal conversation. Okay, thank you everyone who's joining. We're still getting more attendees joining, which is great. But let's go ahead and get started. I want to start by saying I apologize for the status of my voice. I had COVID for about 2 weeks, and I am very happy to say that I am fully negative and generally symptom-free, but I had a really vicious COVID-related cough that has taken a toll on my voice. And so that's why I sound like this. So I'm going to do my best. Welcome to this conversation about Tennessee versus Department of Education, where women won a massive win today with this ruling. And Lauren Levey and I are going to talk a little bit about what the ruling does and what it doesn't do. I want to thank you all for being here, but I also want to say we prefer that WDI webinars are women only. So if you are a man who has joined us, we would invite you to watch this webinar later on YouTube and let this space, this visual space and the chat space be only for women. So if there are men here, thank you for your interest. And please watch us later on YouTube. So I'm going to start tonight's conversation with a little bit of a history, because we have to understand the relevance of the Bostock decision. The Bostock decision was handed down by the Supreme Court in 2020, and it was a combination of 3 cases. 2 of those cases involved situations in which gay men had been fired by their employers. And those 2 men were complaining that firing them on the basis of their sexual orientation, which they had done, constituted unlawful sex discrimination. There was a 3rd case called Stevens versus Harris Funeral Homes. In that case, it had nothing to do with sexual orientation. The plaintiff in that case was a man named Amy Stevens, who demanded that his employer consider him a woman for all purposes. And Stevens demanded that he be permitted to wear the uniform that was required for female employees. And he demanded that he be referred to as she and her and as Ms., not only by employers and colleagues, but also by customers and guests of the funeral home who had because it was a funeral home, customers and guests necessarily had recently lost a loved one. And Stevens was demanding that all customers and guests refer to him using she and her pronouns and as Ms. Stevens. And the Supreme Court, for better or worse, I think unquestionably worse for women, combined all three cases. In the Stevens case, the Women's Liberation Front filed an amicus brief before the Supreme Court explaining why it is important to maintain the material reality of sex in the law and not to grant that transgender or gender identity has any legal basis. And Women's Liberation Front, Wolf, filed that brief only in the Stevens case. Wolf had no problem with Zarda or Bostock complaining that their employers had fired them because they were gay. Nonetheless, the court combined those three cases, and the decision that ended up getting issued in 2020, which is referred to as Bostock versus Clayton County, said that for employment discrimination purposes, discriminating against anyone on the basis of sexual orientation or transgender status constituted unlawful sex discrimination. That's all the Bostock decision said. I think personally, and I know that Wolf thought at the time and still thinks that that was a very bad decision because it enshrined the phrase transgender status in law without defining it at all. Nonetheless, that's what the Bostock decision did. Now, the Biden administration has spent the past 2 years running around all over the country, lying to the American people and telling the American people that it did two things that it did not do. The Biden administration is lying to the American people in saying that the Bostock decision applies outside the context of employment discrimination. It does not. It very expressly, the Supreme Court very expressly said it was not talking about bathrooms. It was not talking about sports. It was not talking about locker rooms. It was not talking about Title IX at all. The Supreme Court very much limited its decision to the very specific situation in which a person was being discriminated against in the employment discrimination context, in employment on the basis of sexual orientation or transgender status. So that's one area where the Biden administration has just been outright lying to the American people for 2 years. The second area where the Biden administration has been lying to the American people for 2 years concerns the phrase gender identity. The Biden administration has been telling all of its agencies and all of the American people that Bostock means that everyone has to redefine the word sex to include gender identity for 2 years. That is not true. The Supreme Court majority opinion in Bostock used the phrase gender identity once in a footnote quoting someone else. Other opinions in Bostock addressed the concept of gender identity, but the majority opinion in Bostock, which is the controlling opinion, did not say that sex must be defined to include gender identity. So when the Biden administration says that it did that, it is lying to the American people. And the Biden administration has been doing that consistently for the past 2 years. Okay, that's history. Now, in the current case, there was a complaint filed in August of 2021. And the plaintiffs in this case are states. And their attorneys are, as far as I can tell, their state's attorneys general. I want to dispel something at the outset, which is there seems to be some Twitter chat to the effect that WDI USA is representing the parties in this case and that we somehow deserve credit for the decision today. We did play a role, and I'll explain that. But WDI USA is not serving as a party or as a representative of any party in this case. The plaintiffs are 20 states, and their attorneys are attorneys general staff within their states. And they filed a complaint in August of 2021. And they made a series of arguments that I personally think, and WDI USA also thinks, were very legitimate arguments. One of their primary arguments is that the series of orders that the Biden administration issued in 2021 regarding Titles 7 and 9 were done in violation of the Administrative Procedures Act. We agree with that argument, and we agree with the rest of the complaint as well. Later in the litigation, in October of 2021, WDI USA filed an amicus brief, also known as a friend of the court brief, in the case, arguing that in addition to all of the completely legitimate arguments that were made by the plaintiff states, the Biden administration's orders also violated the 14th Amendment to the United States Constitution's Equal Protection Clause, because they required discrimination against women and girls on the basis of sex in violation of equal protection. We filed that brief in October 2021. We learned approximately a month ago, I don't recall the exact date, that the court was not going to admit our amicus brief into evidence. But in its decision rejecting our amicus brief, the court made abundantly clear that it had read every word of our brief and it understood the points that we were making. And I think on the basis of that, we have to assume that WDI USA's amicus brief arguing that redefining sex to include gender identity constitutes unlawful sex discrimination under the Equal Protection Clause of the 14th Amendment, that the judge at least took that into consideration when deciding today's imposition of a preliminary injunction blocking the Biden administration's 2021 orders in 20 plaintiff states. So that's some historical context. I'm going to turn it over to Lauren now to say some things about today's decision itself.
Thanks, Kara. So that my voice isn't great either. I'll try. I'm having allergies. It's not COVID in my case. It's allergies. No difference. To the plaintiff states included Alabama, Alaska, Arizona, Arkansas, Georgia, Idaho, Indiana, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Montana, Nebraska, Ohio, Oklahoma, South Carolina, South Dakota, and West Virginia. And when I count that up, I only have 19, so I'm missing one, but I guess you can find that somewhere. For our purposes, I think it suffices to notice that they are red states. These are red states, and that's totally significant. Meaning Republican-leaning states, and I think that I'm gonna put in a plug for WDI USA at this point here. They, as Kara mentioned, they got it right. I mean, they really, it was a good complaint. The plaintiffs got it right. It would have been good if they had, if our amicus brief had been accepted. But even without it, the arguments that they made, the procedural and the substantive arguments that they made were arguments that we agree with. And I think that it was so good because of the work that WDI USA has done. We've concentrated our state legislative advocacy work in those states, and we've sent those states a model bill. We've sent them, we've sent them letters explaining how they were getting it wrong, because Republicans and radical feminists, Republicans they have an odd, they just don't get it right. They don't have an argument that's likely to win. Our argument is likely to win if we can just be heard, So I think that I want to give credit to the state legislative team for the quality of the plaintiff's case. So as Kara mentioned, well, let me just go to what the court did. The court did first gave its own version of the background of the case, and as Kara mentioned, the court stated that the Bostock case was specifically narrow. The court pointed out that it was a narrow decision. It had only to do with employment law and no other area. And it also pointed out that the executive orders in question, the executive orders being challenged, cited Bostock and then pushed them beyond Bostock. And in effect, what the executive orders did was they added sexual orientation and gender identity to the already protected category of sex. But as I said, they extended it beyond employment. So the federal agencies' response, they responded to Biden's executive orders. The education department explicitly said that Title IX now means sex and that sex includes sexual orientation and gender identity. And they sent, the education department sent what they called the Dear Educator letter that in effect said that. Then the EEOC, the Equal Employment Opportunity Commission, I guess, which is about employment, sent what they called a technical assistance document to their people and to the states, right? And what it did was it gave examples of what employer misconduct might look like. It was said to be advisory only. The court didn't buy it. The court didn't buy that it only had advisory impact. So plaintiffs were states that are employers and educators who receive federal funds. That's who the plaintiffs are. And their allegation was that the executive orders, Biden's executive orders, are procedurally and substantively unlawful under the Administrative Procedure Act and also under the United States Constitution. And what the plaintiffs sought was an injunction to ban the enforcement of the orders and also other relief, declaratory judgment and other judgments. The defendant was the Biden administration, and they were seeking here, to dismiss the entire action. And their grounds for dismissing it there were two. One was that the court lacked jurisdiction, which was technical, and the court went into that in a really technical way, and I won't, you'll thank me. And the other ground was that the plaintiff failed to state a plausible claim, and it should be dismissed. So the court, that's what the court was considering. So in general, an injunction, it requires a showing that it's necessary to prevent immediate and irreparable harm. That's true of injunctions. So this court weighed the 4 factors necessary for injunction. First, is the claim likely to, is the action likely to succeed on the merits? Second, is without an injunction, is irreparable injury likely? Third, would the granting of injunction harm other parties? And fourth, is the injunction in the public interest? So the discussion, most of the discussion that we care about had to do with those four factors. So the ruling was, as to the first thing, which is the action likely to succeed on the merits? The court ruled yes. On procedural grounds, the court ruled that the defendant's guidance documents are rules that are subject to public notice and comment. That's, rather than being an advisory, or rather than being anything else. The defendant wanted to frame it as something that didn't require notice to the public and an opportunity for the public to comment. That was sneaky. You know what I mean? That was just really sneaky. They didn't want us to know. They wanted this thing to go into effect without any discussion. And that's been typical of their approach, as you all know, probably. Everywhere, so the court ruled that, and I think that's really, I think that's wonderful. I mean, I was really so happy to read that. These rules should have been subject to public notice and comment. And so therefore, because they weren't, the court ruled that the plaintiffs there's a good likelihood that the plaintiffs would win on the merits. Second, would there be irreparable harm without the injunction? The court ruled that the state's ability to enforce its laws against sex discrimination were harmed here, are being harmed here, right? As long as there's no injunction, because the states were caught between possible liability for sex discrimination by, against women on the one hand, and then liability for sex discrimination on the basis of gender identity on the other hand. So the states were in a precarious position where they couldn't win. They were between a rock and a hard place. There was liability here and there was liability here. There was no, so they needed injunctive relief on that basis. Third, would the injunction harm other parties? Sure. The court ruled, yes, it would harm the defendant, but it also ruled that the defendant has no legitimate interest in enforcing procedurally invalid documents. And it had already said that this was procedurally invalid. And then the fourth is the injunction in the public interest. Yes, of course, the correct application of law it is in the public interest, is what the court said, and the Administrative Procedural Act was violated by the defendant. So, yeah, that's pretty much what the ruling was, and so it granted this preliminary injunction. Now, I think I haven't had time to think about what the import of this is. I don't know exactly what this is going to how it's going to play out. But
Do you want me to jump in, Lauren, or do you want to keep going?
Well, let me just make one stab at it, and then I'll turn it over to you. Okay, let me make one guess. It's just a wild prediction, but I think we're going to have two countries. We're going to have two countries side by side, and one of them is going to recognize gender identity, and the other one is going to recognize sex, as we understand it, right? But one is going to protect women on the basis of sex, and the other is not going to protect women. It's going to protect men who lie about their sex. And this is going to be a living example, side by side, right, of these two ways of going forward. And I think that's really going to be valuable to us. The only thing that I can think of that comes anywhere close to it in the history in American history as I know it, is when there were slave states and free states. What you had was this living example side by side of what's enslavement looked like, and then you had the possibility of no enslavement, at least under the law, right? And there was this incredible tension between the two parts of the country, and I kind of think that this is going to be very, very undermining to the proponents of gender identity going forward, because it's going to be a living example of justice for women. I'm going to turn it over to you now.
Okay, so first of all, there's a request for a link to the ruling online. I don't have that. What I do have is an account with the federal system that I can download rulings, and so I have the PDF. Let's see if WDI can make the PDF, which is perfectly fine. It's a public document. Let's see if we can make the PDF available to anyone who wants to read it. So Lauren went in some really interesting directions there. And I wanted to just say a few things about the ruling itself. I want to say that to people like me and Lauren, reading rulings like this is very exciting because we sort of understand what the court is saying behind the scenes. But I also want to say this. I think that everyone who wants to fight for the sex-based rights of women and girls, including everyone in WGI USA, would love to see a ruling from a court that says that gender identity is stupid and that women and girls have sex-based rights under the law. I think we would all love to see that. This ruling isn't that. This ruling did not say that the Biden administration has it wrong by redefining sex to include gender identity. As Lauren pointed out, the ruling does say that the Biden administration has it wrong when it wrongly misinterprets Bostock to say that sex must be interpreted to include gender identity. But this ruling is not a full-throated repudiation of the Biden administration, nor is it a full-throated defense of women's sex-based rights. And I understand we would all like to see that. But the reason this ruling is not that is that it was never going to be that. That wasn't the argument put forth by the plaintiffs. And the plaintiffs, I think I will reiterate what Lauren said, it's a very good complaint. And it makes some very effective legal arguments as to why the Biden administration was wrong to do what it did throughout 2021 by redefining sex to include gender identity throughout federal administrative law. It's a really good complaint, and it did its work, and the judge delivered, and we should be really happy about that. But it is not a full-throated defense of women's sex-based rights. But here's why I'm not too upset about that. For one, as Lauren said, the court takes the administration to task for its complete for its complete disingenuousness about how it portrays the decision in Bostock. Let's be clear. The Biden administration has just been lying for the past 2 years about what the Supreme Court did in Bostock. It's just lying. And the court takes it to task for doing that in ways that are very restrained and judicial. But if you're used to reading court opinions, you can read that into the opinion. You can read that the court is taking the Biden administration to task for its complete misrepresentation of Bostock. And I really appreciate that about this opinion. The other thing is that if, as Lauren said, what the court ruled is that the plaintiff states are likely to prevail on the merits of their claim that the Biden administration violated the American Procedures Act by doing what it did over the course of 2021, redefining sex to include gender identity. Would I like to see a complete repudiation of all of that? Would I like to see a federal court say that gender identity is ridiculous and that women and girls have sex-based rights? Of course I would. But this isn't going to do that. And I think that's okay, because what this court has done has taken the first step to signal that the Biden administration can't just get away with these redefinitions with no notice and public comment. And if what this order ultimately ends up doing is getting rid of the 2021 Biden memos and letters and fact sheets, et cetera, on administrative grounds, I'm fine with that. I am totally fine with that as an outcome, even though it is not the justice that we would all like to see for women and girls. I think that's all I wanted to say about how I read the opinion today. And then, what Lauren said, I think that Lauren makes some really interesting points about, are we going to be living in two countries? Are we going to be living in a place where half of our country thinks that sex is important and half of our country thinks that gender identity is more important? Maybe. That's very interesting. I hope not. But if that happens, we'll just keep fighting. I do just want to say the most immediate practical import of today's decision is that the Biden administration's memos, orders, letters, fact sheets, interpretive guidance, et cetera, from 2021 that redefine sex to include gender identity are simply not in effect in the 20 states. So if you are a woman living in those 20 states that Lauren named, I think the only one she omitted is Tennessee because that's the main plaintiff. But we have a list of the 20 states. If you are a woman or a girl living in one of those 20 states, you are not subjected to the Biden orders from 2021 that allow men to pretend to be women. So congratulations, seriously, congratulations, women and girls who live in those states. This is a massive win for you. It is not a massive win for those of us who live in blue jurisdictions who are not parties to the complaint, because we still are subject to those Biden orders from 2021. And there are good questions about whether anything can be done about that, which is kind of what Lauren was hinting at when she said, Lauren is speculating that probably not. Lauren seems to be speculating we probably won't be able to convince the gender ideologists to join the red states to protect women and girls on the basis of sex. I don't know if Lauren's right or not about that. But I do just want to congratulate all the women and girls who live in the states that were plaintiffs in this lawsuit. You are no longer subject to these tyrannical, horrible, lying orders that the Biden administration issued in 2021 with respect to Title 7 and 9. Congratulations. This is great news for you, and I hope you celebrate. I want to say a few words about what's likely next in the lawsuit, and then we'll go to discussion and Q&A. Most likely what will happen is that the federal government will submit a notice of appeal in the district court, which is totally normal. They will probably also submit a motion to stay pending appeal. That's fancy legal speak for they will probably file a motion to get the court to go back on itself and release this injunction. I don't like to speculate about what's going to happen in legal matters, but I will in this instance to say that if the federal government files a motion to stay pending appeal, I would be very surprised if this district court granted that motion because of the strength of the language in the district court's opinion from today. I would be very surprised if the court would go back on its own self. So if I'm right, the federal government will file a notice of appeal, and then it will be before the Sixth Circuit Court of Appeals. And then the federal government has another opportunity to ask for a stay of the preliminary injunction. I have no idea what the Sixth Circuit would do with such a motion. Again, the motion would mean, dear Sixth Circuit, could you please pull back this preliminary injunction? I don't know what the Sixth Circuit would do about that. We have two precedents out of the Sixth Circuit that might shed some light. One precedent out of the Sixth Circuit is the case of Amy Stevens himself, the man who demanded that his employer consider him to be a woman. The Sixth Circuit ruled in favor of Amy Stevens on that question. Also, we have the case of Nicholas Merriweather, also out of the Sixth Circuit, where the Sixth Circuit ruled that Nicholas Merriweather, as a public university professor, cannot be compelled to use wrong sex pronouns. So it's very difficult to know where the Sixth Circuit is ideologically on all of these issues that we deal with. All that we know is that the district court, the lower court, issued a preliminary injunction saying the Biden orders no longer, for the time being, are no longer in effect in these 20 states. And the Sixth Circuit will essentially have to decide if the district court abused its discretion in imposing that order. So this could be a very long, drawn out, years-long litigation before we find out what's ultimately going to happen. But I do think this case could ultimately go before the Supreme Court. I will be very interested to see if the Supreme Court is interested in issuing a nationwide injunction on the 2021 Biden orders. But that, in my estimation, is what I think we can probably expect to see in the coming months. And I think that's all I have to say with my really grovelly voice. Lauren, do you want to add anything, or should we go to Q&A and discussion?
Let's go to Q&A. There's some interesting questions out there.
What are some of the interesting questions out there?
Let's see. Lorraine asks, how can attendees find out if an AG from their state is involved? Well, it would be an attorney general from one of those 20 states who would be involved in that. I think that's the short answer. Carol asks, can you share the link? I think that's been, we don't have it. I think that's been answered. Sally asks, wouldn't individual states trying to introduce gender identity in place of sex fall foul of the same constitutional issues raised in this case? If not, why not? Yeah, this is an action here that was an action for, I mean, this ruling was about a preliminary injunction. And with respect to preliminary injunctions, the law is that it only applies to the plaintiff states. But you know, if the underlying issues in the case were to reach, you know, if it were declared, if these executive orders were declared unconstitutional, clearly it would apply to all the states. You want to add something to that, Karen?
Well, and that's exactly what we were asking for in our amicus brief. We were asking that the court consider the argument that the federal executive orders violate the 14th Amendment's Equal Protection Clause because they constitute unlawful sex discrimination. And that question did not get before the court. I wish it had, but it didn't. But yeah, I mean, part of the issue here, as Lauren said earlier, is that what the federal orders do is they bind the states, all 50 states. They bind the 50 states in their capacities as employers and as educators. And they tell all 50 states, you have to interpret sex to include gender identity for employment and education purposes. Now, it's these 20 states who have laws on the books that say, no, we actually think sex is important. We have laws on the books that protect the sex-specific sports for women and girls. We have laws on the books that protect single-sex spaces for women and girls. And what the state said is, there's no way that we can enforce our own laws protecting women and girls' sex-based rights and also comply with your federal executive orders. We can't do both. And so we're in a bind. The state said, we either have to enforce our own laws that protect women and girls' sex-based rights, which means risking federal legal enforcement, lengthy litigation, the removal of billions of dollars in federal funding, or we have to rescind our own laws, which are otherwise lawful. So the states were in a real bind. But could the states just voluntarily decide to go along with the federal orders? Sure, they could. They'd have to repeal their own laws, but they could do that, but they don't want to. Are there other Q&As in the Q&A box, or are they all in chat?
I was going in the Q&A box. Why don't you take a look and see what you'd like to answer?
Oh, it's hard for me to follow the chat box.
No, there's a Q&A box that has some questions left in it.
Leslie has, this is a very long question. Does WDI USA actually think the current Supreme Court is inclined to extend Bostock outside of employment? That's a really good question. And it's prefaced by a mention of, no, it's not prefaced by anything. Do we think that the current Supreme Court is inclined to extend Bostock out of employment? I want to hear what Lauren thinks, and I think Leslie wants to hear what you think too, because she points a question to you specifically about your balanced presentation of the decision and our relationship to the states involved. I am not at all persuaded that in 2020, when the Supreme Court decided Bostock, that it really had any idea of the repercussions that it was going to have. And part of the reason I say that is that it enshrined this phrase, transgender status, in Supreme Court law without defining it even once. And it's almost as though these people in black robes on the Supreme Court are just willing to accept that there's such a thing called transgender status. They don't know what it means any more than you know what it means, or any more than I know what it means. They just kind of threw it out there and said, okay, this is a status and we're going to say it's protected. One thing the Supreme Court did, I think, effectively, well, it turns out to not have been effectively, it's effective for the purpose of the opinion, is it says you can't really talk about transgender status without talking about sex. And I think that's true. And they made that point explicitly. But I don't think they had any idea about the relentlessness of the very well-fueled movement to protect gender identity in the law. I highly doubt the Supreme Court justices had any idea what was coming. So I don't know the answer to your question, Leslie. Do we think the current Supreme Court would expand it beyond Title VII? Today, I'm kind of inclined to think no. If 2 years later, if the Supreme Court is actually paying attention to the havoc that was wreaked by their opinion in 2020, then I would think no. But Lauren, what do you think?
Well, it's hard to say that there's a different Supreme Court now. It has a different composition from the Bostock Court. And I think the jury is out on that, on how they'll rule, so to speak, because this court this court has shown itself, in my opinion, to be very susceptible to public opinion. This is a political court. This is a political court. And so I think that whether they decide to recognize and protect so-called gender identity when and if it comes before this court, it can be influenced by what we do. So, I mean, that's the best I can do with it, but I think that we can have an effect on this court.
So Carol wants to know the impact in blue states. There's essentially no impact of today's decision in blue states, which is to say that the Biden administration's orders from 2021 on Titles 7 and 9 remain, as far as I can tell, in effect in blue states, which means that they can strong arm your institutions into allowing men and boys to be demanded to be considered women and girls. They can strong arm your institutions to allowing men and boys to force themselves into women's spaces and sports. The Biden administration can strong arm all of your institutions to do whatever it wants under its executive orders, because the executive orders remain in full force in blue states, which is part of the reason why it's unfortunate that today's injunction was not nationwide. However, it's also just worth mentioning the plaintiffs, if I'm reading the decision correctly, the plaintiffs asked for a nationwide injunction and they did not get it. But if I'm also reading it right, they asked for a nationwide injunction, but they didn't argue all that strenuously for it. And that's in part because there's very little precedent supporting a federal court's ability to impose a nationwide injunction on states that aren't asking for it. So what the court says in its final footnote on the last page of the opinion is that the plaintiffs asked for a nationwide injunction, but that the court wasn't going to do it, in part because 30 states didn't ask for an injunction. And if they're not asking for it, the court was not willing to read anything into that. Now, I think we all know why the other states didn't ask for the injunction. But the judge probably does too. But as a member of the court, his job is not to personally opine on that or to speculate about that. His job is to enforce the law and interpret the law. And what he said in the final footnote is that nationwide injunctions are very, very rare and they require extraordinary circumstances. And he was not willing to impose a nationwide injunction in this instance on 30 states that hadn't asked for it. Lauren, is that your read too?
Yes, that's what they said. That's what the court said. There's a question from Mary Beth Fielder. She says, I'm new to your group and would like some clarification about your position regarding protection for transgendered people. Do you think they deserve protection against employment and housing discrimination, but not protection when there's a conflict between sex-based protection? So no right to infringe on sex-based protection in sports or protected spaces. WDI is, our mission is contained in the Declaration on Women's Sex-Based Rights, which positions itself against the concept of gender identity and transgenderism. Sex is real and gender isn't. We're radical feminists. That's our position. So we don't recognize a coherent class of people called transgendered people. We don't know what that is. It's never been defined, and you know, we see it as a linguistic device, really, that's used to undermine the sex-based rights of women. Now, if you'd like, you might find it interesting to take a look at the EFAA, which is a document that WDI USA has written to. We've written it as a replacement, as a rational, as a reality-based replacement for the so-called Equality Act, which is presently stalled in Congress, but which would protect gender identity as part of sex throughout law. And what we do with that document, with that proposed legislation, is we protect all people who do not. I mean, we protect women on the basis of sex, and we protect same-sex attracted people on the basis of sexual orientation, and we also protect everyone on the basis of nonconformity with sex-based stereotypes. So if you're a man who presents as feminine or a woman who presents as masculine, you would be protected under the EFAA. However, presenting in a non-stereotypical way for your sex would not, under the EFAA or under our proposed legislation, would not give you any of the rights of the opposite sex. Your sex is immutable and innate. Hope that answers your question. I would have a look. I suggest having a look at that. It's on our website.
So I'm never sure how to pronounce your name. I don't know if it's Zahn or Zane. I never know, but she always asks very good questions. Is there a path through which the courts can be compelled to define gender identity? You know, I think that's complicated, and so far they've just been rubbish at it. They just use it. The Supreme Court did not use it in Vostok, but federal courts in many cases throughout the country just use the phrase gender identity with no definition. Now, is there a path to compelling them to do it? I mean, it's hard to compel federal courts to do much of anything, but sure. I mean, in theory, one could ask for that, either in written briefings or during our oral arguments, but they're very good at getting around it. And I have been very disappointed until today with the federal judiciary's blind acceptance of gender identity as a legitimate concept. Sally asks, can blue states decide to follow today's judgment if they want to? What blue states can do if they want to, what it means to follow today's judgment, in effect, would be to enact laws that protect women and girls on the basis of sex. And that would be the equivalent of following today's judgment. There's no following today's judgment other than enacting laws that protect women and girls on the basis of sex. There's nothing for blue states to really do here unless they want to take action to protect women and girls on the basis of sex. But this judgment today doesn't otherwise affect blue states, as far as I can tell, other than it might set up some really interesting questions about how on earth is the federal government going to go ahead and administer these new orders when we've got this patchwork of different laws across the country, and the federal government can enforce its orders in 30 states, but not 20 states. I mean, that'll set up a really interesting series of legal questions. Emily's question, what happens when there's a new president? Might this go away in blue states too? Sure. So in 2016, the Obama administration issued something called guidance that it's sort of like Biden light. It directed the Department of Education to interpret the Title IX regulations such that sex would include gender identity. The Women's Liberation Front sued the Biden administration on that basis and argued that the Obama administration had violated the Administrative Procedures Act in the same way that the Biden administration has most recently. And that lawsuit was eventually dismissed because things changed in 2016 and a different administration came in and withdrew the Obama guidance. Whatever anyone thinks about the change in administration in 2016, I'm just saying as a factual matter, that's what happened. So yes, things could change with the new administration. What else is going on here?
I see some stuff in the chat, some discussion about definitions and why suddenly, when it comes to gender identity and transgenderism, that there's an relative absence of definitions, and I think that's because of where this ideology comes from. It comes out of postmodernism, and postmodernism doesn't define stuff. In postmodernism, words, stuff is subjective, right? And it's plastic, and the underlying. I mean, you can see it in Matt Walsh's recent video that there's a certain animosity, in fact, toward definition, but of course, it's not sound law. It's not sound law. How can you enforce something without definitions?
Carol asks, is there any potential for individuals in blue states to sue pointing to the decision? Sure. I mean, it just requires a plaintiff. Carol, if you can persuade your attorney general to sue, that would be great. I have almost no confidence that your attorney general would be willing to do that. But yes, it takes a plaintiff. It takes a lot of money. It takes attorneys. That's partly why this case has been so useful, because it's been the states that have sued, and they have their own built-in litigators. They have their own attorneys general, so they didn't have to hire outside counsel. I'm only going to have a couple more minutes. Where are we? I did want to say something about what Lauren said. I think that a lot of people are astonished that government officials, actual elected officials, and appointees with lifetime appointments to the United States federal judiciary are enacting laws, issuing regulations, coming out with judicial decisions, using words that have utterly no definition. Lauren's exactly right. This comes from postmodernism and the resistance to define things in any coherent material way. But that in and of itself does not explain why our government officials are doing it. We understand why the weirdo academics do it, but why are our elected officials and our our judges with lifetime federal court appointments doing it? And I don't know the precise answer to the question of why they're doing it, but I do know that they're doing it. So I think we need to wrap up, but I think my concluding message to everyone would be, if it seems crazy that our elected officials and our federal judiciary are enshrining words that have no meaning in law, if that seems extraordinary, astonishing, and unacceptable to you, that's because it is. That is what is happening. And you are not the crazy one. This is what is happening. It is that bad. Sorry, but it's true. Okay, should we wrap up then, Lauren?
Yeah, I think we're good.
All right. One last question. If the lawsuit is successful, will it just require a public comment period, or is it possible that the courts could find this to be a violation of women's sex-based rights and block it entirely? I think it's highly unlikely that any court is going to find this to be a violation of women's sex-based rights. Oh, did Austin stop it?
It's still recording, if that's what you're asking.
Okay. I don't think any court anytime soon is going to find that the Biden orders have been a violation of women's sex-based rights, although I very much wish they did. Anything else, Lauren?
Well, if we get a new president, it could be executive order is only as good as the executive is in power.
All right, everyone, thank you so much for joining us tonight. We'll close here. Have a great night. Celebrate. This was a great win today. It's a great win for women and girls.
Thanks for coming.